On this episode of Force Options Training, we bring back JR to break down a recent BC Appeals Court award to a man injured in a wrongful arrest and the importance of duty of care. JR, thank you for coming back. You are back by popular demand, with your episode 1 of De-escalation being the most listened to episode this season.
Well, thank you very much, Eric. It is a pleasure to be back. I do enjoy doing my best to share some knowledge where appropriate, and excited to discuss today's topic.
Today we're going to talk about a recent British Columbia Appeals Court decision. This is McLellan versus Canada, where the court upheld a $1.3 million award to a man injured in a wrongful arrest. So in 2010, in Kamloops, British Columbia, police were responding to a schoolyard for a report of a man with a knife. Police attended, they took 2 people into custody, neither of which ended up being the subject of complaint, and McLellan was injured during this process. So McLellan said the injuries were sustained during the handcuffing itself, when the officer dropped their knees on his back, but more so when he was lifted off the ground by his handcuffs, which he said put him into a planked position, thus causing serious injuries to both shoulders. So it's not so much today we're going to talk about the actual incident itself, or should the officers have done this or done that. More about what can we take away from this and what can we learn, and I'll kind of hand it over to you to give a little debrief here.
Yeah, thanks, Eric. I remember reading about this case. It was sent to me by a colleague, and I think there was a few takeaways from this, certainly from a law enforcement training perspective. It's still fairly rare that we'll see a settlement of this nature in Canada anyway. It's not that uncommon in the U.S., but $1.3 million is a large settlement, and we won't debate the justification of that. But certainly some takeaways from this. The part of I have the opportunity to present to numerous groups, both in law enforcement and in the civilian world, regarding use of force. And certainly in the civilian world, there's a common theme about when force should stop in policing in general, or in particular. And we talk about officers doing the right things for the right reasons, being in lawful execution of their duty, acting on reasonable probable grounds, and using only as much force as is necessary, or that the force is reasonable. And that's often when the debate comes in through different triers of facts. And the overriding thing that seems to keep coming up in these civilian groups is that when someone is placed in handcuffs is generally when they feel that the force should stop. And those of us that have worked in this field for quite some time still know that people can fight when they're in handcuffs, whether it be through kicking or spitting or headbutting, or even just manipulating their bodies in different ways to essentially assault officers or the public for that matter. But generally, that's when people think that the force should stop, and certainly when things are caught on video and optically, and even when the public are watching, when officers use force to people that are restrained, it is very regularly put into question. Where I work, we do train people different ways to control people that are in handcuffs to make it harder for them to fight, and you can do that just by controlling different parts of their bodies in a firm but somewhat benign way. And I think part of the issue in this case, and has come up in previous cases as well, is when officers continue to use force once people are restrained. And this was certainly the case in this particular file.
It wasn't just the method of cuffing that the courts took issue with, it was also the justification for it. Looking at some of the information that the officers had available prior to their attendance, as well as the fact that McLellan was cooperative throughout their encounter.
Yeah, I did go over the case here, Eric, and you're absolutely right. And when officers are given a little bit of information, and that sort of helps guide their tactical considerations. In this case, it was a knife call, and those of us in the field know that a knife call or any sort of an edged weapon call can present grievous bodily harm or death if you're reviewing the National Use of Force Framework, which is a tool that helps articulate some of the stuff that we do. But there's other information that needs to be gleaned out of this call. Like I think in this one, they might have had some additional information that they could have run on their computer-aided dispatch or CAD caller to gather some more information that would have helped get a better description of the subject involved, and maybe would have guided their decision-making process perhaps a little bit differently. I mean, it's sometimes a little bit unfair to armchair quarterback these events, but that's what the civilian oversight and trier of fact does anyways. So they could have maybe got a little bit more information. And even when in situations like this, when we do put people in mechanical restraints and we feel there's an articulable justification to do it, there is nothing wrong with communicating to the subject involved and sort of letting them know this was the information I had, this is why we did what we did. The subject still might not be happy with the end result, but you give them that opportunity to sort of have that conversation and if appropriate, offer them any sort of medical assistance or intervention. And another thing that's often helpful in these situations is offering to have the subject speak to the supervisor that can maybe articulate a little bit better than the officers directly involved. I don't know if any of that happened in this case, and even with the handcuffing, there are ways that we train. I know both my understanding, the RCMP and certainly municipal agencies at the academies train ways to get people up from a handcuff position that can be a little bit more humane than just sort of yanking people up. And the way we train here, if people are still fighting you or being highly active resistant on the ground, maybe that's not the right time to get them into a standing position and move them. We can sort of take a breath and reevaluate the situation and do our best to communicate to the subject if the subject's willing to listen on that day. But there's certainly ways that we do train to get people into a standing position as opposed to just lifting them directly from the handcuffs or their shoulders.
This is something that's come up in a couple of the breakdowns, is the way they lifted them off the ground and duty of care coming into question.
Yeah, in this case, certainly from the comments of the judge in this particular incident, he was a little bit critical of the officers, certainly from the language he used regarding duty of care and getting the subject back into that standing position. I mean, regardless of the situation, whether it's a very high risk call, some sort of a critical incident that officers are going to. Once they've had an opportunity to get control of the situation, and duty of care should play into it. Whether you've realized you now have put someone in handcuffs that maybe didn't necessarily, looking back, hindsight, deserve to be put in handcuffs, all the way to putting a very high-end violent offender in handcuffs, because that's, again, earlier to my earlier statement, once we sort of get control of a situation and get someone in mechanical restraints, that's when, regardless, and even if you've had to use a high level of force to get that subject into restraints, once they are in restraints, we have to have a duty of care during out the entire incident as best to our ability.
Excellent. And this is something else that came up in this trial as well, is about the use of force and tactics. And then reading off this is the use of force and tactics should consider subject behavior. In this case, the plaintiff was cooperative and not be based solely on the nature of the call. So in this case, man with a knife. And as we kind of discussed previous to this, that can actually go both ways. You show up to a high risk call and it ends up being nothing, or you could go to something like a shoplifter and next thing you know, there's a knife or kind of weapon involved.
That's very true, Eric, and I think a big part of training the officers is that continual assessment and guiding their decision-making process. There, you have to constantly assess, and then you're planning what to do next, and then acting. And you sort of hit the nail on the head there. Is you go to what can potentially be a high-end call. Or what appears to be a very violent call involving weapons, but then you show up to that call and you realize that the information you were given doesn't totally match what's going on, and you can come into a situation like that, and you could be dealing with a very cooperative person, and that's even still dealing with even if it is one of those high-end calls, but you're dealing with a very cooperative person, that's going to dictate your officer response. And if you're dealing with a highly cooperative person, or even moving up the framework, someone who's mildly passive resistant, you can't be using hard physical tactics to deal with that person. And on the same note, if you go to a call that you think is just I think you mentioned a shoplifter, or that's something we discussed, or any sort of a vagrancy type call, or dealing with a person that by all accounts you're expecting a certain thing, and then when you're dealing with out comes an edged weapon, or they become highly assaultive and violent to deal with, and then of course you have to assess that and alter your tactics in that situation. The other side of that duty of care thing, too, is if someone might be having a knife and they're threatening you, but as soon as they drop that knife, and if there's no longer any weapons, and if it's safe to do so, then you have to sort of alter your tactics when you're going in to take physical control. So it is sort of on both sides, and the national use of force framework and other tactical considerations are certainly something that have to guide us as officers when we're doing these things, and we have to do our best to keep our emotions at a reasonable level because of the profession we've chosen to work in. Because often when emotions get high, our tactics get low, and we have to use these things to guide the decisions we make.
I like that. The days of us just being able to use officer safety as a blanket statement justifying our actions, I'd say that's gone. And that's something that came up, and specifically from the judge, I believe in this case, they said officer safety is not a phrase you can use to justify all actions, and they point out you must detail the specific officer safety concerns that are relative to the people you're dealing with.
Yeah, that's it's funny because certainly when I first started, and maybe this was a training thing that I'd like to think we've corrected over the years, but we would do things in this profession of policing, and sometimes it would be involving using force or restraining people or other stuff, and then the default was just officer safety, and that became a standard that was used in court. It was used in report writing. It was used in explaining things to civilian oversight. I think that we've done a better job, certainly as trainers, and getting this information out to the officers in the field, that you can't just say it's an officer safety issue. You have to be very specific. If there is an officer safety, you have to do a better job of talking about the totality of the circumstances and why you believe it's an officer safety issue. If it's statements made by the subject, if it's actions by the subject, if it's things you see regarding weapons on the subject. And it's not just officer safety. There's officer safety concerns, there's public safety concerns, and even in some cases there's subject safety concerns that sort of are all overriding things that help the officers make good decisions on both their actions and the force they use, and an articulation tool for any sort of trier of facts or any sort of a process that they have to explain later why they did and what they did in the moment.
Excellent. And again, it's along the lines of that's one of the reasons why we could put handcuffs on people. But again, you have to articulate why.
That is a great example, Eric, because this is something that it has come under scrutiny, handcuffing, and again, that sort of safety things. I mean, the courts have said there's really only 3 reasons why police officers or anyone in law enforcement can put people in handcuffs, and that's safety, escape, or evidence in relation to the offense. But again, it's not just safety, it's officer safety, public safety, subject safety, and it needs to be articulated in every instance.
JR, thanks again for doing this, coming on and discussing some of these topics. And again, for anybody that wants to read the actual decision or check out the case, it's McLellan versus Canada. So thank you again, and I'm sure we'll have you back in the new year.
Thank you very much, Eric, and always a pleasure to come on and speak when given the opportunity.